the word betrayal, I don't think is strong enough.
When a community is promised care and safety, but the system protects a predator instead, the damage can last decades. Welcome to Make Your Case, the podcast where attorneys break down the most impactful cases of their careers and the stories behind them. I'm Joe Douglas, longtime investigative journalist and founder of Clear Eyed Media, where we produce legal videos that help lawyers win cases and reach better outcomes. Today I'm talking with Peter Janci, a Portland-based attorney who has spent 18 years helping survivors of sexual abuse find their voice, often as the first person they've ever told. In this episode, Peter walks us through his team's work on behalf of Native American boys sexually abused by a doctor working for Indian Health Services and what they learned about how early warning signs get ignored. He also explains how they pushed a rare legal theory built around treaty promises and why, in the end, he believes there's no substitute for decision makers hearing directly from survivors. Peter, thanks for being here.
Thanks, Joe. Good to be here. Good to talk to you.
You take on a certain kinds of cases, I've noticed, particularly in the sex abuse and victim advocacy or survivor advocacy, for lack of a better term, realm. What drives you, or what kind of puts you into that world? Why do you take on those kinds of cases?
Yeah. Well, I got into the work sort of unexpectedly. I came into this area of practice around the time that the Catholic diocese abuse cases were really taking off. In the early 2000s, the Archdiocese of Portland was the first diocese in the country to file for bankruptcy protection based on fears about the exposure from civil litigation by victims of sexual abuse. And at that time, I was in law school. I was interested in constitutional issues and sort of First Amendment issues. And I got linked up with an attorney who became my mentor, has since passed away, but friend and former partner, Kelly Clark. And Kelly brought me in as a law student to research the First Amendment and how issues around religious liberty and those types of protections sort of intersected with the claims being brought by victims of sexual abuse in the Catholic Church. And, I really enjoyed the dynamics of the work. I enjoyed the challenges, the intellectual challenges of these cases. And more than anything, I really found a lot of satisfaction in helping survivors of sexual abuse and sexual violence find their voice. The folks that we represent often we're our firm or, our attorneys are the first people that they have ever told about what's happened to them. Oftentimes it's been decades since the sexual abuse they suffered as children. And, most people that have been through this experience and start to think about coming forward, it takes a tremendous amount of courage, and often they feel like they're alone and that, they don't have anywhere to turn. And so, it's really an honor to get to step into that space and listen to people's stories and advocate for them and walk alongside them in this process that is really aimed at trying to help them get healing from a trauma that usually impacts all aspects of their lives. And so I've been practicing in this space for 18 years, I believe, this year, and have found it tremendously rewarding to get to work with this clientele.
Has that been in Portland the whole time, or have you been in other states doing this kind of work?
We've always been based in Portland, but I've done this work around the country. One of the dynamics in child sexual abuse cases in the last couple decades has been a trend of statute of limitations reform. And so various states have enacted statute of limitations reform sort of at different points along the last couple decades. Often those are structured as sort of finite windows of time. They call them windows where people in, for example, California or New Jersey or New York have a year or 2 years or a set number of years to bring their cases, regardless of how long ago it happened. And so that dynamic has led to doing work in the states that I mentioned, California, New Jersey, New York. We've brought cases in Arkansas and just a whole host of states, and have also handled some cases in Canada and a couple cases in other places in the world. I handled a group of cases in Bangladesh, handled a case or two in Africa. Those are the ones that are coming to mind. But
Wow.
yeah, it's been sort of a happy accident to get to work in those other jurisdictions and sort of get exposure to other legal systems or rules or whatnot. So
Great. And so I always ask everybody when they come on this podcast about to bring a case that we discuss all kinds of stuff, but a notable case in your career that comes to mind that we can kind of explore.
yeah,
And sometimes it's either good or bad. And what is a case like that for you?
yeah. I think one of the recent cases that came to a conclusion that really stands out to me has been our work on behalf of Native American boys who were sexually abused in the context of medical care that they received on Indian reservations. And so we recently were proud to announce an $18 million settlement on behalf of a group of those victims, which brings the total recovery for those, because this is a second group that we've represented. And so, we've now been able to help as a part of a team, recovering $32.5 million for 20 victims of Dr. Stanley Patrick Weber, who was a predator working for the federal government on Indian reservations in several states in the United States.
Yeah. And so was there a moment where you realized in this case, like this wasn't just one bad doctor, this was an institutional failure? Or what did you see first?
Yeah, it like most of our cases, even where we end up representing a group of people, it started with one victim coming forward, and um, we had one victim reach out to us, and we quickly saw that that victim had been prompted to come forward because there was some media attention coming onto the criminal investigation and prosecution of Dr. Weber. And this was really, I think, a group of cases that highlighted the power of victim stories, but also the importance of the media reporting on these situations and helping to shed light on the problem. And so when we got involved, Dr. Weber had been arrested and was being prosecuted for sexually abusing boys. And what was one victim became a group of victims, and then ultimately a second wave of victims. But in our investigation, and then also through the media investigation, we learned quickly that Dr. Weber's abuse of our clients was part of the long pattern. Ultimately, Dr. Weber had worked for Indian Health Services for 30 years by the time he was arrested. And we learned that that Indian Health Services was aware of concerns about Dr. Weber from the jump, from the minute he was hired, or very close to the moment he was hired. Indian Health Services and his supervisors became aware of predatory behavior. Early on, he took a teenage boy, on a trip to Europe. And that was just one of a long list of warning signs and dangers that were ignored, and frankly worse than ignored, when other coworkers reported him or tried to get Indian Health Services to take action. Um, Really, the federal government actively concealed what he was doing. They punished whistleblowers, and they engaged in, a response pattern that we've seen with other organizations where they transferred him. So, he was working in a couple different settings. He was moved to the Blackfeet Reservation in Montana, and as complaints started to mount and concerns arose to a point where they couldn't be ignored, ultimately the federal government transferred him in the mid 1990s to the Pine Ridge Reservation in South Dakota, which is the Oglala Sioux reservation, and you know, dumped basically a predator into a new community, unsuspecting community, where parents and those involved had no warning, had no awareness of all the prior warning signs, and then let Dr. Weber sort of have, um, his run of the place there for almost 20 years, and he's badly sexually abused some of the most vulnerable kids you can imagine, and all the while with the federal government receiving repeated warning signs and reports and not taking action to stop him.
Yeah, and so from what I understand, he was at the Blackfeet Reservation in Montana from I think 1992 to 95, and what I'm seeing in the reports is that right?
Yeah,
And then from in the 95 to 2016 in the Pine Ridge Reservation in South Dakota. Does it sound
correct. Yeah, mid
correct?
90s to 2016. Yeah, right around then. Yeah.
Yeah, and so and then he's ultimately I believe he was convicted in these cases in 2018 and 2019, I think, in Montana and in South Dakota. So you were brought in
Yeah,
while
he
those
was.
cases were being adjudicated, or had he already been convicted?
Well, I think we were first contacted prior to the first adjudication, and but he was subsequently convicted, and we did not initiate sort of our lawsuit until after he had been convicted.
Okay. And so and you said I saw you quoted in I think in the Montana Free Press. You said like these were some of the most egregious violations of trust you dealt with. What made this? And I know personally because I've worked with you on a couple of cases that, and I've I also was like
Yeah.
when I was a reporter in Portland, I dealt with you sometimes too, and I saw the cases you took on. So that's a hardcore thing to say, especially coming from you. What made this case different,
Yeah.
if anything?
Yeah. Yeah. I mean, we've definitely seen some of the worst of the worst, but this case did stand out. I think if you've never been to the Blackfeet Reservation or Pine Ridge or some of these places, it would be hard to fully drive home the level of poverty that exists in some of these areas. These were Native American boys living on reservations, in facing very significant poverty and other sort of socioeconomic challenges,
Mm-hmm.
and they were um, they were told by the federal government, as were the other members of their tribes, that through treaties that their tribes had entered into, with the government, that the government would provide them certain services, including medical care, and they went to get treatment during some of the most difficult times, facing ailments and injuries, and they went into these private exam rooms to get help, um, and they were met by a predator in a white coat, and in the context of trying to get help, he exploited them, he took advantage of them, he badly sexually abused them, and um, and also exert pressure on them not to tell people what had happened. And it's I think most people, it's just there are a few professions or a few types of professionals that we all rely on for help in our lives, and a medical doctor is one of those. And you combine all these factors, and you just think about what these boys were already up against, and they were going somewhere they thought should be safe to get help, and instead they were exploited. And I think also the culture that they were living in, made it even more difficult to disclose about. Our clients who testified about that it was very difficult at that time,
Hmm.
um, to in this culture to acknowledge male on male sexual abuse. I mean, it was just, so they were facing a whole handful of challenges and stigmas, um, and really had nowhere to turn to. And some of them were actually, out of their parents' care, and were, in group homes or in foster care type settings when this happened. And this doctor took them under, supposedly was taking them under his wing and helping them out. And in Pine Ridge, he sort of escalated things, and he started programs where he was supposedly going out into the community and sort of building rapport and trying to build medical connections with folks in the community who were underserved. And it gave him cover to engage with youth in settings where he wouldn't normally be able to. And that led to him having boys to his homes. And in some instances, he even drugged and sexually assaulted the boys. And there's some evidence that he may have videoed or take photographs of them. So, um, yeah, it was, when you combined what they faced just in the dynamics, and this sexual assaults and abuse that they suffered, and then you add on the layer that the most powerful government on earth had the opportunity to prevent this very early on, and had all the information that they needed to step in and stop this from happening. And instead of prioritizing the safety of these kids that the government had made sacred promises to in the form of treaties, they just ignored them, and they just prioritized their own, they prioritized their medical staff and their doctor, and just decided that it was more important to keep this pediatrician on board and, be able to say that that position was filled than to protect kids from some of the most heinous abuse imaginable. And that was the word betrayal, I don't think is strong enough.
Yeah, it's a really horrible case. The how what was the age range of these kids, these victims? Do you remember?
Yeah, I think generally they were between 10 and 15 years old.
Wow. And so by the time you come in, well, first off, how did you come in? Because this is a federal case. These are they're not in Oregon.
True.
So how did they end up reaching out and finding you?
Yeah. Well, our firm has developed a reputation as one of the go-to firms for victims of sexual abuse. We had done some work in the state of Montana on behalf of victims in other contexts, including sexual abuse victims in the Boy Scouts of America, and have litigated some cases in state court in Montana with co-counsel. And so we were contacted, and we reached out to our colleagues at the Colton Home law firm, and said, "Hey, this looks like a terrible situation. I think we should investigate. Let's work together on this." And Shane Colton and Tanis Holm have been great partners of ours, and we decided to dig in, and we started our investigation. And through that process, folks heard that we were working, we were looking into these cases, and other people started contacting us. And before we knew it, we had a group of people that wanted to try to see if we could, get some justice and accountability for them. And that sort of started the next phase of, okay, now we have clients. How are we actually going to make this happen? Because cases against the federal government are notoriously difficult. There are special rules made to protect the government and make it more procedurally difficult to bring cases against the federal government. And we had that plus the added challenge of cases that were at that point decades old. And so that was sort of the next turning point, as how are we going to try to get justice for these clients?
Yeah, and so there, it sounds like an enormously challenging case. One of we focus on this podcast. I kind of focus more on like storytelling and also the elements of kind of getting people to talk, which I
Yeah.
can only imagine if a case these happened in the 90s and you're brought in maybe what 2016, 2017, or I don't know.
2017-ish.
Yeah.
Yeah.
So like a lot of these victims were probably adults by the time he got brought in.
Oh, yeah. All of our clients were adults by the time that we were on
Yeah.
this, and many had been adults for quite some time.
So what were if any, like what were the big challenges there with like was it like with getting them to talk or to sign on to be a part of the lawsuit, or was that what were some of the big like things you had to get through for this
Well, I think,
case?
yeah. I think that some of it was logistical. I mean, these were clients that often were living in fairly far-flung areas, and these are not the kinds of conversations that are, I think very effective to do via telephone or even Zoom, as great as it is. So, part of it was traveling and meeting with folks face to face. Part of it was, I think, the stigma around men admitting that they've been exploited or violated, and especially Native American men. And so it was a process of trust building and trying to create a sense of safety that these folks could trust us with their stories. And one of the dynamics that we see often with child sexual abuse victims is it's a process. The disclosure process and the storytelling process takes time, and often victims sort of have a certain place that they can go to in an initial conversation, and
Mm-hmm.
then you need to come back and say, okay, we need to talk some more about this factor or this aspect, and we need to understand a little bit more about that. And I think there's a little bit of testing and trust building that goes on in that disclosure process over time, to make victims feel comfortable enough to tell you, the most some of their most difficult secrets. And unfortunately, in these types of cases, we have to know the ins and outs of what happened, really specific details, because there's all types of legal defenses that get raised, and it's not enough to just say, hey, as a victim, I was sexually abused by this doctor. We got to know when and where and how, and so that part of clients trusting us with their stories, and then us trying to set up a process where we can tell their stories effectively, help them tell their stories effectively, and hopefully move the needle either in the judicial proceedings or in settlement negotiations to try to get some modicum of justice for them.
Yeah. So initially, what do you do to build trust? Because you've done this many, many times throughout your career. This is not
Yeah.
new for you. What do you do when you're sitting down with someone who's been abused horribly for the first time?
Well, we try to make sure that they understand that at least their conversations with us are confidential, strictly
Mm-hmm.
confidential under the attorney-client privilege, and that we will not share what they share with us without their authority. We try to give them, I think one of the strengths that we have is that we have a proven track record in this area, and we can point them to similar cases that we've handled, and give them some reassurance that we know what we're doing when it comes to sexual abuse cases. Um, I think that, part of it is just being, you know, survivors of sexual abuse and that type of betrayal, trust is sort of the ultimate issue, right? I mean, they have had their trust betrayed, and so every step of the way, we do our best to try to explain where we are in the process, what could happen, what their choices are, and a lot of it, I think, is giving survivors agency in the process and letting them know that we work for them, that they get to make the decisions. We will give them our best advice, but if they want to move forward in this process, that they are in control, and that they get to call the shots. Um, and then I think, part of it is we do some intentional work about trying to be educated about trauma and about trauma responses. We've had times where we loop in mental health professionals. We have folks on our team who we've intentionally added in our sort of intake positions who have training as social workers. And so we're trying to build a process that understands where this unique clientele is and what they need to feel supported in the process and to be able to share their stories. And I guess the other thing I'd add is that we try to be intentional about giving them multiple different ways to share information with us. So there may be, we've had teenage boys, for example, who can tell us certain parts of the stories, but when it comes to telling us verbally the ins and outs of the sexual abuse they suffered, sometimes for them a starting place is, hey, here's a form, a written one-page form that lists out a lot of different types of experiences that you may have had.
Mm-hmm.
And it can be easier to start that conversation, giving them the chance to check a box and then talk about, okay, you've endorsed this. Can we talk a little bit about where that happened and how many times? So some of it is just a mix of trial and error over, a lot of years of doing the work and figuring
Mm-hmm.
out how do you empower people to be able to tell their story in a way that's both um, as fulsome as it can be and also as sensitive and recognizes their dignity, even though they're talking about things that can be extremely difficult to communicate.
Yeah, it's like the trauma informed work. I understand. It's like it's oriented around not causing harm with the process, right? Like not actually making that traumatic, which is must be a very thin line to walk. And that's interesting that you have a form that they fill out. I could see how that can kind of distance it a little bit. Is there anything else that you guys do, or you and your team, to sort of walk that line? Or do you maybe deploy certain associates that might, like, for example, maybe if it's a woman victim, you might have a woman talk to a woman, or I don't know. Are there other things you
Y-
kind of do or try?
Yeah, we do. I mean, so we try to just be um, to be express about it with clients and potential clients about what they need and try to help them understand that we're not asking for this information out of curiosity. We're trying to get the information that we need for the case and do it in a way that responds to their needs. And there's all kinds of things. I mean, if we're meeting with someone face to face, we try to let them choose where they want to sit in the room. Some people want to sit by
Mm,
the door. They want to know that they've got an exit because when they talk about these experiences, they're back there. They're back there as a kid being violated, and they need to know that they can get out.
yeah.
We check in about taking breaks. We'll give them options. If they don't, if they feel more comfortable talking to a man or a woman, we try to accommodate that and we're fortunate to have a staff that allows that. Um, so yeah, I think a lot of it is about being intentional and explaining the why of what you're doing, and also giving them the option. A lot of times we'll tell them, like, if we get to a place in the conversation where you need a break or you just can't talk about that, please tell us and we'll figure out how we deal with that problem. So it's a little bit of a collaborative process in giving them the power to identify what their needs are and then trying to work within those needs and be intentional about it. But the limitation is we're working inside of a system that is not trauma informed. I mean, at its core, bringing a civil case or bringing a criminal case, we can we do our best, but at the end of the day, if you want to pursue a civil case, there are some things that are just required. You can't get away from the fact that you're going to have to at some point disclose what happened to you. And if that's too hard, that's okay. It's not the right decision for everybody. There are lots of people that we talk to and counsel about what the process will look like. And sometimes people opt not to proceed. And that's okay. We do that as part of our job, is giving victims the information that they need to decide whether civil litigation is an appropriate tool for them in their healing. And it's not for everybody. And if it's not, then that's okay. Like, not, you know, it, some people, it's more important to be able to not have to go through that experience than to see a civil case all the way through. So, we're really trying to build a litigation process that empowers survivors and is one of the tools for them in their healing. And it's not the right tool for everyone.
Yeah, and so, I mean, is this like the hardest part of this case, or was there another part of it that was more difficult for you, like the stuff that the public doesn't see kind of behind the scenes? What was the most challenging thing?
Well, I think there are a few challenges. One was that, legally, the hurdles were huge. And what we ultimately had to do was we brought these cases as violations of the 1855 and 1868 treaties that the federal government had entered into with the tribes, because the other legal options were even more challenging, believe it or not.
Mm-hmm.
So it was basically unheard of. There had been one case that had tried to do that before, and we decided that we were going to pursue it that way. So we filed a lawsuit in a special court called the Federal Court of Claims, which is a court that is established to deal with contracts and treaty violations. And the federal government's we argued that the federal government's conduct with regards to Weber and Weber's conduct violated promises that the federal government had made to the tribes and tribe members back in the mid 1800s. And specifically, there were provisions in these treaties that provided that the federal government agreed to indemnify and to pay for damages caused by, one of the clauses says, bad white men living amongst the natives. And there's another clause that basically said that they would compensate for the depredations of basically white men living among the Native Americans. And so we said that Dr. Weber's conduct was a violation, and that other people who were higher in the chain of command who ignored this conduct were violations of those treaties. And we began pursuing that litigation in the Federal Court of Claims. Which brings me to another major challenge in the case, was that the timing of the original case was basically during COVID, and everything slowed down, government slowed down, and it was extremely difficult to try to push these cases forward. Ultimately, I think what moved the needle, we had a viable theory, and we were pursuing a viable, theory in these treaty violations. But I think what moved the needle in the case was the storytelling, and it was the power of our clients' stories and setting up processes within the settlement discussions to have our clients have the opportunity to directly share their stories and to be heard by decision makers. And I think when folks who maybe otherwise would have been arm's length from, oh yeah, those are the plaintiffs in this lawsuit, heard directly from our clients telling them what had happened to them, and not just what had happened to them as kids, but what it had been like to live with the damage that caused and what their lives have looked like since then. I've seen that in a number of our cases where our clients have the opportunity to tell their stories, and there's just no substitute for hearing directly from the victims, whether in a settlement context, whether through a settlement demand video, whether through direct presentations live in the room. There is no substitute for hearing the survivors' stories and what it was like from their perspective. And I've seen that in several scenarios, and there's usually never a dry eye. And not necessarily in this case, but I've had other cases where afterwards a decision maker from the defendant pulls me aside and says, we had no idea. We had no idea what this was like or what this really meant.
Mm-hmm.
And we're going to make sure that we try to figure out how to do the right thing and get this resolved. Um, so
Wow. Yeah. I mean, that's a great summary of all the challenges you're facing and some of the most powerful things that you find in like dealing with cases like this. I saw that there was an independent report in 2020 described leadership knowing about suspicious behaviors, quote unquote, and failing to act. What were some of those warnings, those key warnings leaders allegedly ignored?
yeah, there were so many. Dr. Weber would curate basically a list of the boys that he wanted to see. He only wanted to see boys. He only wanted to see boys of a certain age. He did things like seeing boys after hours in the exam rooms alone. He brought a couch into one of the exam rooms. He Kids were complaining, making complaints to nurses and staff about touching that went ignored. There was a couple really heroic coworkers of his. One was a psychologist who had worked with sex offenders and had seen predatory behavior and was throwing a fit about what they were seeing from Dr. Weber. And that person was not just ignored, but was ultimately penalized by the agency, was retaliated against.
Mm-hmm.
Um, and then he was taking kids to restaurants. He was having kids to his home. He was having kids spend the night at his house. He was At one point he was assaulted by the family of a victim who shared with about what had happened, and the police were involved, and Indian Health Services was notified that there had been this attack on him, and still they turned a blind eye. So the evidence was just totally insurmountable that this guy was a predator. It's hard to imagine what they would have needed to see to take action given what they did know and what they ignored.
Yeah, and the report suggests that the leaders didn't want the warnings to be true because like dealing with them would have been messy and embarrassing. And in your experience, is that the pattern in a lot of these institutional abuse cases?
Yeah, we see that dynamic a lot. I think, what we saw here was similar to what we sometimes see in public school cases and other cases where, we had a you had a rural outpost that was difficult to find specialized employees like a pediatrician, and you had low budgets that made it difficult to pay people well. And so instead of addressing those sort of institutional problems and getting the right funding or getting authorization to hire the right kind of people, you just saw sort of an institutional instinct, I think, to try to avoid having to, basically take the path of least resistance. And so the easiest thing to do was to hope it wasn't true and to ignore it and hope the problem goes away and not have to rehire, not have to terminate or report them to the police and rehire. And we've seen that in public school cases. We've certainly seen in the Catholic Church, the instances of transferring abusive priests. We saw in the Boy Scouts of America allowing abusive scout leaders who were charismatic and well liked. It was easier to let them transfer troops than anger parents who didn't understand what was going on by kicking them out sometimes. So unfortunately, yeah, those institutional dynamics I think are at play in a lot of these scenarios. And then with Dr. Weber, I think you saw the classic situation where it was, there was sort of a halo effect of, well, he's a doctor, he must be he must be a good guy. He holds this credential, like he's a priest or he's a teacher.
Yeah.
These are positions that I have respect for. So maybe we'll just assume the best. And when it comes to child sexual abuse, you can't just assume the best.
Yeah, certainly. And so the 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 clients in this case, what it's kind of, it seems obvious maybe to an outsider what they want or what they may have wanted, but what did they most like want from your perspective in dealing with them? Like money, accountability, change, or kind of all of the above?
Yeah, I would say these clients are, in my experience, were the same as the vast majority of other clients that I've represented, where, it's really not about the money. The money is what our system has to offer. They can't give them, our system can't give child sexual abuse victims back their childhood. They can't give them a life that is um, without the impacts of the trauma that they've suffered. And what most of our clients want is to be heard and to be acknowledged and to have someone say, whether directly or through the process or through the resolution or the result, that what happened to them was wrong, that it never should have happened to them, that it wasn't their fault. And also, to hope that through that process that they're doing their little bit to make sure that it doesn't happen to somebody else. And so, the money matters. It matters as a symbol. It matters practically because our clients often have treatment needs, whether it's mental health or substance abuse or other treatment needs that are expensive. And there's also an economic impact from, not having necessarily pursued as much education or career training. But at the end of the day, I think the money mostly for our clients operates as a symbol and an acknowledgement, and also fulfills that hope that by an organization having to put their money where their mouth is and feel a little bit of the pain in a practical way, that they will be more motivated to make sure that if warning signs come up about another doctor or another trusted leader, that they have another incentive to do the right thing, not just, maybe for the right reasons, but because they know the impact it'll have on their own organization if they don't.
Okay. And then sort of the how do you corroborate claims like this when the abuse happened many years ago and the institutions basically have all the paperwork?
Yeah. Well, we have to uh, get the paperwork from the institutions and whatever that may involve. Sometimes that's a protracted process and filing motions with the court and getting orders compelling them to produce the records. But in medical care abuse cases, which we've done a number of and are currently working on, a large group of those in the state of Oregon, one of the upsides is that there often is documentation, at least about the fact that the visits happened, that the doctor, saw this patient, had the opportunity to, commit the abuse that's alleged. So, in most of these instances, or maybe all of these instances, we had records from Indian Health Services showing that our clients had seen Dr. Weber during the time frame that they alleged that they were abused. And so, that really shifts the dynamic and it puts the defendant in the position of saying, okay, well, you've got a convicted pedophile who we know has abused lots of boys, and we know that he had opportunities alone with this boy. What's your basis for saying that our client's testimony about what happened to him isn't credible?
Yeah. So this, and then this led to an $18 million settlement, what I understand.
Yeah, the most recent settlement was an $18 million settlement on behalf of that second group. In total, we have represented the large majority of victims who have come forward about Dr. Weber, and there have, to our knowledge, there have been at least 20 victims who have, in combination, been compensated a total of $32.5 million for the sexual abuse by Dr. Weber in Indian Health Services.
And have you been involved in all of that?
The vast majority of those are our cases. There was
Yeah.
another group of victims who also brought a lawsuit,
Hmm.
and that part, those victims make up part of that total $32.5 million.
And so, and it's okay. I mean, I don't know if you're limited to what you could say about it, but about like how that came together and what it represents for those victims, that settlement, those settlements?
Yeah. Well, the first case, was in active litigation and resolved through a mediation process. The second group of cases, we were able to sort of build on that momentum and also resolve those through a mediation process. And I'm somewhat limited about what I can say, other than that, our clients had the opportunity to be heard, and we think that that had a significant impact on the resolution process. And I think it meant a tremendous amount for our clients and their families. There were a lot of parents that we heard from in this process that felt tremendously guilty about this happening to their child sort of on their watch. I think like any parent, would feel like, did I miss something? Should I have seen something? Should I have known? And I think for parents to see that, their children get that acknowledgement, and also for the process to help push the public release of these investigations, which the federal government fought very hard to keep their internal investigation a secret, and the media was a huge ally in pushing to make sure that that investigation was released. And so, sort of the combination of the litigation and the media attention and the media storytelling and the storytelling from our clients all sort of allowed a public dialogue and public information about just how much the federal government knew. And I think that assuaged a lot of the parents' feelings that, there was just no way a parent could know in Pine Ridge in 2015 that the federal government had known about Dr. Weber for 20 years prior to that. And so I think to learn that on the one hand is devastating, that this could have been prevented, but on the other hand, it sort of shifts the focus where it should be, which is his supervisors and the agency that he worked for that had every opportunity to know what he was doing and drop the ball, or more than drop the ball, chose to turn a blind eye to what was going on.
When you're negotiating with the federal government, what do they typically fight hardest for? Like, do they fight liability, damages, or sort of the overall optics?
Yeah, I think the largest challenge that we face in this case, which you can see from the court docket, so it's public information, was the statute of limitations. So it was a fight on liability. And they were trying to defend the case by saying, basically, okay, even if everything you say is true, we shouldn't be responsible for this because too much time has passed and these kids should have come forward sooner, which is, unfortunately, it's a tactic that we see in these cases, these historical child sexual abuse cases involving all kinds of institutions, is pointing to this sort of technical procedural defense. And, the nature of that defense is basically they could admit that everything we say is true, but just say, you're too late. You should have come forward earlier. And it's part of the reason why statute of limitations reform is such an important trend around the country, because we know from the social science literature, from psychologists, that it takes victims really decades to come forward. It takes them decades to understand that what happened to them is not something that was in the rearview mirror, that it's still affecting their lives today. And there's research out there that's very clear now that the average age of disclosure for most victims of sexual abuse is 52 years old. And there's a huge percentage of victims that will never tell anyone in their lifetime. So, it's all the more reason that, we are staunchly in favor of the political trend around the country to either change or eliminate statutes of limitations. Because when it comes to child sexual abuse and the unique way that it impacts people, there shouldn't be a time limit on that. Victims don't get a time limit. Victims don't get to say, well, 5 years have gone by, so I don't have to deal with this anymore. And it seems that the perpetrators and those who conceal and harbor them also should not get that benefit.
I saw Blackfeet leaders describe like a lasting community harm and ongoing fear, which is totally understandable. And you talked about like some of these things to answer this question, but how do how do we avoid this from happening again? And like, what would a prevention plan look like from your perspective?
Yeah, I mean, I think it's multifaceted. I think there's a within the agency, I think that there were, as a part of the investigation, there were a number of mechanisms identified that would have helped prevent this situation, both in the grievance process and how those are investigated and responded to. I think that some things have changed. That some changes, such as having chaperones in medical visits, especially with children. There's some very basic things that can be done that would have made this either prevented it or made it much more difficult to evade detection. And it didn't evade detection. I mean, frankly, it was the response that was the problem. But in addition to sort of those systemic changes that can happen inside of medical visits and inside of the bureaucratic response, I think one positive development we're seeing in this work now, again, having been at it for almost 20 years, is I think there's a community education and understanding that has changed drastically. And I think that we now are, we're building on that, and we're seeing communities like these, the Blackfeet and Oglala Sioux, um, uh, embrace victims and understand that we need to believe victims when they come forward and support victims,
Yeah.
and try to get rid of the stigma that stops people from reporting. And I think that's a huge difference I've seen in my career. There's so many more cases that I see where victims come forward very close in time now, or in their late teens or early 20s. Whereas when I started my career, that was almost unheard of because there was just so much to overcome, I think, for a young person to be worried that they wouldn't be believed or that they would be, blamed, or that, those types of stigmas would be asserted against them. So, I think we are making progress. And I think these cases and the attention to them help educate people on how predators operate and how we can, be aware. And the reality is there's always going to be, predators like this that try to seek out opportunities in youth serving settings because
Mm-hmm.
predators go where there are victims. But everyone around them and everyone else that works in there can be aware that this is a problem, that any trusted adult can be a danger, and be aware of the type of red flag behaviors that indicate that abuse may be happening. Because at the end of the day, it's almost never the case, abuse almost always happens in secret, and it's almost never the case that somebody walks in on something as it's happening. Usually these situations are discovered and stopped because people respond to the grooming and the boundary violations and the red flag behaviors, and they stop it earlier, and then, that process often uncovers, unfortunately, that there have been other similar conduct.
Yeah, and then I'd have to ask about this because you really are kind of a subject matter expert on this grisly topic. But if I'm a parent and I'm listening to this, without you don't have to, I'm not asking you to give legal advice, but just what are some of the things you recommend people look out for, if for your kids, like about potentially abuse happening or avoiding being in that predicament altogether in an institutional setting?
Yeah. Well, I think that, unfortunately, some of what we need to be on the lookout, it can be hard to distinguish from sort of people that are really passionate about kids. But we want to look at folks that seem to have a disordinate interest in children, that are looking for or are orchestrating opportunities to be one-on-one with children. And be taking boundary violations seriously. It doesn't mean that every boundary violation or every red flag means that abuse has happened, but we have to stop that sort of chain, because what predators do is they sort of build on, a small boundary violation here, a small boundary violation here, and they start to build a sort of more intimate secret relationship. And so whether it's trying to spend one-on-one time with the child, whether it's right now, I think we're seeing a lot of the use of technology, whether through social media, messaging or text messaging. There's really not good reason for trusted adults to have sort of secretive one-on-one communications with children. We need to try to push for transparent connections, transparent interactions, have parents be on text strings that kids are on. Don't allow kids to be friends with, adults on social media, or at least limit, their social media settings so there aren't either platforms or messenger apps that allow for that type of one-on-one contact.
Yeah.
And then there's sort of the classic lists of, gift giving, buying things, making comments that seem a little off or a little too intimate, or, sexualized jokes, comments, things like that. I would just say that parents should trust their guts at this point, and if they see something that they think feels a little off, say something about it. And even if the person's intentions, weren't bad, it's okay to call out behavior that goes beyond a parent's comfort level and say, hey, you know, with my kid, I don't want you doing that. I don't want you talking about that. And when we see sort of more extreme boundary violations or boundary violations that we think give us a real concern, it's important to report that, because as a parent, you're seeing your little slice of the interactions with your child,
Hmm.
but the supervising employing organization may have information about similar behavior towards a number of other different children, and we need to make sure that that information is sort of on record and that it is known to the supervisors, because one slip up in the way that you say something may not be that meaningful, but a bunch of different comments that are just over the line to a bunch of different kids may suggest a serious problem.
Are there any warning signs that institutions or parents should treat as sort of like a huge red flag, kind of like drop everything? I don't like so that this doesn't happen.
I think, I think, one orchestrating one-on-one contact, especially secretive one-on-one contact, is a major concern. I think physical touch, and if it's obviously, if it's sexual abuse, that's sort of more obvious. But I think physical touch that is making a child uncomfortable or making a parent uncomfortable. And then I think if you see deception, if you call somebody out on something and they say, well, that's not what happened or whatever, I think we need to believe kids and believe that they're telling us the truth. And if you see someone that is denying or spinning and your senses go up, I mean, predators are manipulators, and they try to ingratiate themselves with parents and with others around a child to try to increase their access and to try to sort of get the opportunity. And then I guess the other thing I'd say is another common tactic we see is that predators often will push the boundaries or get kids to engage in conduct, maybe even not terrible conduct, but things that are a little over the line or that maybe their parents don't want them to do,
Hmm.
to make them feel like they're complicit in the relationship. So if you see a situation where an adult seems to be encouraging or allowing or pressuring a kid or to, you know, all kinds of things, have a little drink alcohol, or watch a movie their parents said they couldn't watch. I'm reaching for little examples, but those things of making kids feel complicit is something we often see in retrospect, that, oh, well, the perpetrator gave the kid alcohol or let the kid smoke weed, or some of these behaviors that both lower their inhibitions and make them more susceptible to abuse, but it also has the effect of making them feel complicit, so that, oh, now I can't tell about what happened because people are going to get mad at me, my parents are going to get mad at me, or I'm going to get in trouble because I smoked pot with the perpetrator. So, and I think that drives home the value of making sure that kids feel like, hey, you can come to me. with what, anything. And, I'm going to support you and believe you, and we'll figure it out together.
Great. And then this is a kind of a lofty question, but I like to ask attorneys these kinds of questions, especially towards the end of these interviews. We're kind of getting towards the end here. What did this case teach you about how power protects itself and what sort of breaks that protection?
Yeah. Um, well, I think this case definitely demonstrated that power protects itself, and that can go up to the various highest levels. And I heard recently in another case somebody say that, well, one of their defenses was sort of like, well, these were powerful, educated people. Like, there's no way they knew what was going on. They wouldn't have turned a blind eye because they're smart and wealthy and powerful. And I just thought, that totally misses the point. The problem in a lot of these situations is not ignorance or a lack of resources. It's a lack of will. And oftentimes it's kind of that club effect of, well, we're going to protect our own. And it's easier to look the other way than to, challenge a charismatic, well-liked sort of member of the club. And so, I think that um, the ways to get around that, or to sort of work, first of all, I think it's going to be a dynamic that's always there, that we're going to have to
Mm-hmm.
always work against. I think educating people so that they understand what the stakes are, and the tremendous impact of child sexual abuse, and that this is not just like, oh gosh, there was this one time bad thing, but they'll get over it, or I can ignore it. Making sure people understand the true reaches of the impact. Um, and then I think, it's frankly one of the major reasons that civil litigation in this area is so important, is that you have to make it more expensive for power to ignore the problem than to act. And so there are these costs and social costs, et cetera, um,
Yeah.
of challenging someone. And that's why it's so important that we push for, frankly, big compensation for victims that are where this isn't prevented, and big jury awards where we can, because the message needs to get across that if you ignore this problem, and if you shift the burden onto this victim and make them live it that for the rest of their lives, you are exposing yourself as an organization to huge liability. And you have to adjust that calculus so that when people are making decisions, they go, yeah, this might be hard to challenge this guy, but we gotta deal with this head on, because if we don't, we're gonna get hit, and we're gonna get hit real hard.
Yeah, and the other thing I want to ask you before we go is, and I have to ask you this really is because, I've worked with you a couple times, and you've made videos and part of as part of the settlement process, or in the goal of reaching a settlement, and the other thing I want to ask you about too is you've also not been shy in many cases about talking to the media, and but this is kind of a two-pronged question, sort of like,
Sure.
why do you create videos in this process, and what value has that had for you? And then sort of like, and also why do you sort of go to the media in some cases, and why do you pursue those different strategies?
Sure. Well, we have used the settlement video process, and very effectively in a number of cases. And you know that you've been someone that we have tapped to help us with that process, although we've used others in the past as well. As a form and as a tool, I think that when it's well done, the settlement video process can allow us to give a presentation that is just more direct to decision makers than oftentimes the process allows up until trial. At trial, our client will testify, others will testify, and there will be a client rep for the defendant who watches all of that. But at that point, it's too late to reach a settlement generally, right? I mean,
Mm-hmm.
we're trying to push to a jury making a decision. The settlement video process really allows us to take the highlights of the presentation that would be made at trial and the story from our clients told directly from our clients where we can, and to deliver that to the decision makers, not their lawyer who's going to write up a memo about what the strengths and weaknesses of the case, but the decision makers, and have them have the visceral experience of hearing that testimony and seeing that evidence and respond internally the way that a juror would at trial. And I just think that that's an invaluable opportunity to try to communicate why we believe the case is so important. Um, in terms of why we go to the media generally, or why we'll cooperate with the media, I mean, we're 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 involved in cases that the media is sort of generally naturally interested in. They're sexual abuse cases, but they're abuse of power and they're large organizations. And so there's already a lot of media interest around our cases. But, you know, we try to make sure that the media is well informed about what's going on in cases when they're interested, because for a couple of reasons. One is that our clients are, usually one person taking on sometimes billion-dollar companies or agencies. We are up against the most well-funded organizations that have huge teams of lawyers, huge PR machines, huge spin factories, and there is an existing, counter effort in almost every case to try to emphasize the good of these organizations and sort of downplay the failures. And so the media is often a huge counterbalance to making sure that the individual experience of the one little guy who was abused gets heard and doesn't get drowned out by all that other noise that's actively being pushed out there. And, you know, there's a lot of different things I could do with my law practice or that my team could do. But we do this because we really believe that, one of the best contributions we could make to the world and humanity would be trying to minimize the amount of child sexual abuse that's going on. I mean,
Mm-hmm.
the impact that it has on people's lives and sort of the impact of broken people's lives on other people and on other communities, I just think it can't be overstated. And so we really believe that it is vitally important to the movement and to helping eradicate the problem of child abuse, to make sure that people understand how it happens and how to prevent it, and to know they're not alone, and to speak up as early as possible, and that sort of we all have to work at this together to try to stop this problem. And I've just seen time and time again with the Indian Health Services cases being a great example that there's just no substitute for really dedicated journalists, shining a light. And we welcome that, knowing that they're not on our side. They're telling the story, right? I mean, they're going to get to the truth. And so there's accountability for everyone. And so we are really careful about bringing cases that we believe in, that are credible, and
Mm-hmm.
knowing that when we come forward, and if the media is interested, that we're going to be truthful, and we're going to share what we know, and trust that when people hear the whole story, that they'll get it and that they'll know where the failures were.
Yeah, and then the last question I like to ask everybody is sort of just throughout your career, what have you learned that may surprise the young Peter Janci, who's like maybe just going to law school,
Uh,
or someone who doesn't know anything about what you do, that may be like something that's counterintuitive or surprising
right.
that you've learned along the way?
Um, well, change takes time.
Mm-hmm.
It's been interesting to see, I think we have made change, but I think you also see that, especially in large organizations, it takes a lot of time and it takes a lot of repeated, um, repeated accountability for organizations to do the right thing. And so turning the ship takes a lot of time. But, I think another more sort of positive that I've seen is that change is possible. And, even if change at the institutional level takes time, change and healing for our clients is possible. And, now I've had the benefit of doing this for a couple decades, and I get the benefit of getting emails and letters from former clients, some of whom I represented 15 years ago or, longer, and getting to hear from them about the changes that they've made in their life and the lives that they've built and the positives that have come from stepping forward and speaking out. And that with a combination of, being believed and getting into therapy and, kind of this cluster of tools, that civil litigation is just one piece of it. But that with support and with effort, victims of child sexual abuse can live a healthy and robust and meaningful life and can heal. Not to say it'll ever be behind them or that healing will ever be complete. I think it's an ongoing process and journey, but it's been a real honor to get those letters and emails and messages and to get to see people build families and change careers and sort of embrace recovery and healing and realize that what we do does matter. And on the days where it feels like organizations aren't changing, or they made the same mistake again, or they're doing the same bad thing again, we can still know that what we do for sort of each one of those individuals does matter, and that it can have an impact.
Great. Anything else you want to add?
No, Joe, I can't think of anything. Appreciate the opportunity to chat with you.
Well, that's it for this episode of Make Your Case. Big thanks to Peter Janci for joining me and sharing what this case demanded legally, emotionally, and ethically. If you found this conversation useful, go ahead and subscribe so you don't miss the next one. Make Your Case is produced by Clear-Eyed Media, where we help attorneys present their cases more effectively through professional video storytelling for mediation, settlement, or trial. And if you're a lawyer with a case or story worth telling, I'd love to feature you on the show. Just email me at joe@cleareyedmedia.com. I'm Joe Douglas. Thanks for being here.